Gaius, Institutes. 1. Book I, Introduction. The Institutes of Gaius F. de Zulueta ed. And trans. 1946, Volume 1 Book 1, Section 1-7, pp. Odd nos. 2-5 footnotes omitted. Book I. 1. Every people that is governed by statutes and customs observes partly its own peculiar law and partly the common law of all mankind. That law which a people establishes for itself is peculiar to it, and is called ius civil, civil law, as being the special law of that tutus state, while the law that natural reason establishes among all mankind is followed by all peoples alike, and is called ius gentium, law of nations, or law of the world, as being the law observed by all mankind. Thus the Roman people observes partly its own peculiar law and partly the common law of mankind. This distinction we shall apply in detail at the proper places. 2. The laws of the Roman people consist of leges comitial enactments, plebiscites, senatus consults, imperial constitutions, edicts of those possessing the right to issue them, and answers of the learned. 3. A lex is a command and ordinance of the populace. A plebiscite is a command or ordinance of the plebs. The plebs differs from the populace in that the term populace designates all citizens including patricians, while the term plebs designates all citizens excepting patricians. Hence in former times the patricians used to maintain that they were not bound by plebiscites, these having been made without their authorization. But later Al Hortensia was passed, which provided that plebiscites should bind the entire populace. Thereby plebiscites were equated to leges. 4. A senatus consult is a command and ordinance of the Senate, it has the force of lex, though this has been questioned. 5. An imperial constitution is what the emperor by decree, edict, or letter ordains. It has never been doubted that this has the force of lex, seeing that the emperor himself receives his imperium, sovereign power, through a lex. 6. The right of issuing edicts is possessed by magistrates of the Roman people. Very extensive law is contained in the edicts of the two praetors, the urban and the peregrine, whose jurisdiction is possessed in the provinces by the provincial governors, also in the edicts of the curule aediles, whose jurisdiction is possessed in the provinces of the Roman people by quaestors. No quaestors are sent to the provinces of Caesar, and consequently the edilician edict is not published there. 7. The answers of the learned are the decisions and opinions of those who are authorized to lay down the law. If the decisions of all of them agree, what they so hold has the force of lex, but if they disagree, the judge is at liberty to follow whichever decision he pleases. This is declared by a rescript of the late Emperor Hadrian. Such footnotes as are there are by CD and explain omissions in the text. 2. Book I, of Persons, Slave and Free. The Institutes of Gaius F. de Zulueta ed. And trans. 1946, Volume 1 Book 1, Section 8-47, pp. Odd nos. 5-15 footnotes omitted. 8. The whole of the law observed by us relates either to persons or to things or to actions. Let us first consider persons. 9. The primary distinction in the law of persons is this, that all men are either free or slaves. 10. Next, free men are either ingenui, freeborn, or libertini, freedmen. 11. Ingenui are those born free, libertini those manumitted from lawful slavery. 12. Next, of freedmen there are three classes, they are either Roman citizens or Latins or in the category of dedici. Let us consider each class separately, and first dedici. 13. By the Elilia censure it is provided that slaves who by way of punishment have been put in bonds by their masters or have been branded, or have been questioned under torture on account of some wrongdoing and have been found guilty of the same, also those who have been handed over to fight in the arena with men or beasts or who have been cast into a gladiatorial school or into prison, that such slaves, if afterwards manumitted whether by the same or another master, shall become free men of the same status as peregrini dedici. 14. Are called peregrini dedici those who in the past have taken up arms and fought against the Roman people and being defeated have surrendered, at discretion. 15. Slaves disgraced in the manner mentioned, by whatever method and at whatever age they are manumitted, and though they were in the full ownership of their masters, never become either Roman citizens or Latins, but are always ranked as dedici. 16. On the other hand, a slave not so disgraced becomes on manumission sometimes a Roman citizen and sometimes a Latin. 17. A slave in whom these three conditions are united, that he be over 30 years of age, that he be the quiritary property of his master, and that he be set free by lawful and statutory manumission, that is iudicta, or by the census or by will, becomes a Roman citizen, but if any of these conditions is lacking, he will be a Latin. 18. The requirement as to the age of the slave was introduced by the Aelia Censure, which provided that slaves manumitted below 30 should not become Roman citizens except if freed iudicta after proof of adequate motive for the manumission before a concilium council. 19. There is adequate motive where, for instance, a man manumits before a concilium his natural son or daughter, or his natural brother or sister, or his foster child, or his children's teacher, or a slave whom he wants as procurator, business agent, or a female slave whom he intends to marry. 20. The concilium is composed in the city of Rome of 5 senators and 5 Roman equites knights, in the provinces of 20 recuperators being Roman citizens. In the provinces, it sits on the last day of the assizes, but at Rome manumissions before the concilium take place on fixed days. On the other hand, slaves above 30 can be manumitted at any time. Indeed, manumissions may take place even in the street, for instance when the praetor or proconsul is on his way to the baths or the theatre. 21. Furthermore, a slave under 30 can become a Roman citizen by manumission where he has been declared free and left heir by the will of an insolvent master, provided that he is not excluded by another heir. 1. 22. Ellipsis. Such persons are called Junian Latins, Latins because they are assimilated to colonial Latins, Junian because they owe their freedom to the Unia, whereas previously they were ranked as slaves. 23. The Unia does, however, not enable them either to make a will themselves or to take under, or be appointed tutors by, another's will. 24. Our statement, that they are incapable of taking under a will, is, however, to be understood as meaning that they cannot take directly, by way of inheritance or legacy, for indirectly, by means of a fideicommission trust they can take. 25. But by no method can those in the class of deditici take by will any more than any other peregrinus, nor, according to the prevailing doctrine, can they make a will themselves. 26. Thus the freedom of those classed as deditici is the lowest, nor are they allowed admission to Roman citizenship by any lex, senatus consult, or imperial constitution. 27. Moreover, they are forbidden to reside in the city of Rome or within the 100th milestone from Rome, and any who contravene this prohibition are ordered to be sold by the state with all their property, subject to the proviso that their servitude is not to be in the city of Rome or within the 100th milestone, and that they are never to be manumitted. If they are manumitted, they are to be slaves of the Roman people. These provisions are contained in the Aelia Censure. 28. Latins, however, attain to Roman citizenship by many methods. 29. To begin with, under the Aelia Censure, if a slave who has been manumitted under 30 and so becomes a Latin takes to wife either a Roman citizen or a colonial Latin or a woman of the same status as his own and has the fact attested by not less than 7 witnesses Roman citizens, above puberty, then, if he begets a son, he is empowered by the statute, on the son becoming 1 year old, to go before the praetor, or in a provinces before its governor, and prove that he took a wife under the Aelia Censure and has a year-old son by her. And if the magistrate before whom the case is proved finds that the case is as stated, then both the Latin himself and his wife, if she too be of the same status, and likewise the son, if he too be of the same status, are by 1a page is eligible in the Veronese Mus. Presumably it dealt with the other 2 requirements of section 17, quiritary title and solemnity of form. The statute ordained to be Roman citizens. 30. The reason why in referring to the son we have added, if he too be of the same statuses is that if the Latin's wife is a Roman citizen, the son born of her is, under a recent senatus consult made on the authority of the late Emperor Hadrian, a Roman citizen from birth. 31. This right of obtaining Roman citizenship, though by the Aelia Censure it was conferred only on those who became Latins on manumission owing to being under 30, was later, by a senatus consult passed in the consulship of Pegasus and Pusio, granted to persons becoming Latins on manumission over 30. 32. Even if the Latin dies before having proved the case of a year-old son, the mother can prove it, and thereby she will both become a Roman citizen herself, if she was previously a Latin. And so will the son, too. And even though the son himself be already a Roman citizen, because born of a Roman mother, she ought still to prove his case, in order that he may become suis heirs to his father. 32a. What we have said of a year-old son is to be taken to apply equally to a year-old daughter. 32b. Further, Under the L. Visalia, persons becoming Latins by manumission, whether above or below 30, acquire quieritary status, i.e. become Roman citizens, by 6 years, service in the police at Rome. A senatus consult is said to have been passed later giving them citizenship on completion of 3 years, service. 32c. Also, by an edict of Claudius, Latins obtain quieritary status if they have built a sea-going ship of a capacity of not less than 10,000 measures of corn, which ship, or one substituted for it, has carried corn to Rome for 6 years. 33. Further, it has been enacted by Nero that a Latin having a fortune of 200,000 sesterces or more, who builds a house in the city of Rome on which he spends not less than half his fortune, is to obtain quieritary status. 34. Lastly, Trajan has enacted that a Latin who for 3 years has worked a mill in the city which grinds not less than 100 measures of corn daily is to attain quieritary status. 3. 35. Furthermore, persons manumitted above 30 and having become Latins can obtain quieritary status by repetition of the manumission, as can those manumitted under 30 on their reaching the age of 30. In every case a junior Latin above 30, whose manumission is repeated by his quieritary owner for by means of iudicta, the census, or will, becomes a Roman citizen and the freedman of him who has performed the second manumission. Thus, if a slave is yours by bonitary title, but mine by quieritary, he can be made a Latin by your sole act, but the second manumission can be performed only by me, not by you, and by it he becomes my freedman. Indeed, if he obtains quieritary status in any of the other ways, he becomes my freedman. But possession of the property left by him at death is granted to you, whatever be the way in which he had obtained quieritary status. If, however, he belongs by both bonitary and quieritary title to the same owner, he can both become a Latin and attain quieritary status by being manumitted by that owner. 36. Not everyone who wishes to manumit is allowed to do so. 37. For if a man manumits in order to defraud his creditors or his patron, his act is void, because the L. censure prevents the liberation. 38. By the same lex also a master under 20 is not permitted to manumit except iudicta and with adequate motive for manumission shown before a council. 38. There is adequate motive for manumission where, for instance, a master manumits his father or mother, or his teacher or foster brother. Moreover, the motives we mentioned above in the case of a slave manumitted under the 30th of May be adduced in the present case, just as, conversely, those we have specified for the case of a master under the 20th of May be applied also to that of a slave under 30. 40. A limitation being thus imposed by the L. censure on manumissions by masters under 20, the result is that, though a master who has reached the age of 14 can make a will and therein institute an heir and leave legacies, he cannot therein grant freedom to a slave. 41. And though the master under 20 is seeking to make his slave a Latin, he must nevertheless show adequate motive before a council, and only then manumit before friends, informally. 42. Furthermore, a limitation has been set on the manumission of slaves by will by the Elfufia Carninia. 43. For a master who has more than 2 and not more than 10 slaves is allowed to manumit up to half their number. One who has more than 10 and not more than 30 is allowed to manumit up to a third. One who has more than 30 and not more than 100 is allowed to manumit up to a quarter. Lastly, one who has more than 100 and not more than 500 is allowed to manumit not more than a fifth. Nor is he allowed, even if he has more than 500, to manumit any more, the lex enacting that no one may manumit more than 100. On the other hand, a master who has only 1 or 2 slaves is not affected by this lex, and consequently has unrestricted power of manumission. 44. Nor has the lex any application to masters manumitting otherwise than by will. Hence a master manumitting iudicta or by the census or before. About 2 lines are illegible, and the translation in italics is a partial conjectural restoration. 2 lines illegible in the Veronese Mus. 4 The translation given in italics is from a conjectural restoration of the text. Friends, informally, is allowed to free his whole household, provided of course that there be no other impediment to their freedom. 45. The rules we have stated with regard to the number of slaves who may be manumitted by will must be taken with the qualification that, where only half or a third or a fourth or a fifth of the actual number may be manumitted, it is always permissible to manumit not fewer than could have been manumitted under the preceding scale. This is laid down by the lex itself, for it would indeed have been absurd that a master of 10 slaves should be allowed to manumit 5, as being allowed to manumit up to half, whereas a master of 12 should not be allowed to manumit more than 4. On the contrary, one who has more than 10, but less than 15, may manumit 5, though this exceeds a third of his actual number, 5. 46. Similarly, if the names of the slaves manumitted by the will are written in a circle, none of them will be freed, since no order of manumission is discoverable. For the Elfufia Carninia and also certain special senatus consults nullify anything contrived to evade the lex. 47. Finally, it is to be noted that the provision of the Elia censure nullifying manumissions in fraud of creditors applies also to Peregrini, so ruled by the Senate on the authority of Hadrian, but that its other provisions do not apply to them. 5. An entire page, which probably gave more details about the Elfufia Carninia, is illegible. Cf. Epit. 1.2.2-3. The translation in italics is a conjectural restoration. 3. Book I, of Persons, Sui Juris and Eleni Juris. The Institutes of Gaius F. de Zulueta ed. And trans. 1946, Volume 1, Book 1, Section 48 to 141, pp. Odd Nos. 17 to 47, footnotes omitted. 48. Next comes another division in the law of persons. For some persons are sui juris independent, and others are alieni juris dependent on another. 49. Again, of those alieni juris some are in potestas, others in manus, and others in municipium. 50. Let us consider first persons alieni juris, for, knowing those, we shall at the same time know who are sui juris. 51. And first let us consider persons in another's potestas. 52. S1 aves are in the potestas of their masters. This potestas is juris gentium, for it is observable that among all nations alike masters have power of life and death over their slaves, and whatever is acquired through a slave is acquired for his master. 53. But at the present day neither Roman citizens nor any other persons subject to the rule of the Roman people are allowed to treat their slaves with excessive and causeless harshness. For by a constitution of the late Emperor Antoninus it is laid down that one who without cause kills his own slave is as much amenable to justice as one who kills another's. And even excessive severity on the part of masters is restrained by a constitution of the same emperor, for, on being consulted by certain provincial governors as to slaves who take refuge at the temples of the gods or the statues of the emperors, he ordained that masters whose harshness is found to be unbearable are to be forced to sell their slaves. Both enactments are just, for we ought not to abuse our lawful right, the principle under which prodigals are interdicted from administering their own property. 54. But whereas among Roman citizens there is double ownership, for a slave may belong to a master by bonitary or by quiritary title, or by both, a slave is held to he in the potestas of the master who has the bonitary title to him, even though he have not also the quiritary. For one who has the bare quiritary title to a slave is not considered to have potestas over him. 55. Also in our potestas are the children whom we beget in a stay nuptiate civil marriage. This right is peculiar to Roman citizens, for scarcely any other men have over their sons a power such as we have. The late Emperor Hadrian declared as much in the edict he issued concerning those who petitioned him for citizenship for themselves and their children. I am not forgetting that the Galatians regard children as being in the potestas of their parents. 56. Thus Roman citizens have the children in their potestas if they take to wife Roman women, or even Latin or Peregrine women with whom they have connubium power to contract civil marriage. For, as the effect of connubium is that the children take the same status as their father, the result is that the children are not only Roman citizens but are also in their father's potestas. 57. Hence it is the practice by imperial constitution to grant to certain veterans connubium with the first Latin or Peregrine women whom they take to wife after their discharge. Children born of such a marriage become Roman citizens and in the potestas of their parents. 58. It is not, however, every woman whom we may take to wife, but there are some whom we must abstain from marrying. 59. For no marriage can be contracted, and there is no connubium, between persons standing to each other in the relation of ascendant and descendant, for instance between father and daughter, mother and son, grandfather and granddaughter, grandmother and grandson. Persons so related who form a union are considered to have contracted a wicked and incestuous marriage. This principle is so strict that, though the relation of ascendant and descendant have come about only through adoption, they cannot be joined in matrimony. Nay, even if the adoption has been dissolved, the legal position remains unaltered. Hence I cannot take to wife a woman who has come into the position of a daughter or granddaughter to me by adoption, even though I have subsequently emancipated her. 60. Between persons collaterally related similar, but less stringent, rules obtain. 61. Between brother and sister, whether born of the same two parents or having only one parent in common, marriage is of course forbidden. But where a woman has become my sister by adoption, though, so long as the adoption stands, there can clearly be no marriage between me and her, yet after the adoption has been dissolved by her emancipation I may take her to wife, or again, if I myself have been emancipated, there will be no impediment to our marriage. 62. A man may lawfully marry his brother's daughter, a practice first introduced after the late Emperor Claudius married Agrippina, his brother's daughter. But to marry one's sister's daughter is unlawful. These rules are declared by imperial constitutions. 63. Also, I may not marry my aunt, paternal or maternal, nor yet a woman who has been my mother-in-law or daughter-in-law, or my stepdaughter or stepmother. We say, has been, because, if the marriage through which the affinity has arisen still subsists, there is another reason why she cannot become my wife, namely that a woman cannot have two husbands at the same time nor a man two wives. 64. Accordingly, one who has contracted a wicked and incestuous marriage is considered to have neither wife nor children. Hence the offspring of such a union are considered to have a mother, but no father, consequently they are not in his podesters, but are in the position of children whom their mother has conceived in promiscuous intercourse, these likewise being considered to have no father, since even his identity is uncertain. Hence they are termed spurious children, a word derived either from the Greek word describing the nature of their conception, or from sine pater owing to their being fatherless. 65. It happens sometimes that children who do not come under the paternal podesters at birth are subsequently brought under it. 66. For instance, a Latin who marries under the Aelia censure and begets a Latin or a citizen's son, according as the mother is the one or the other, will not hold him in podesters, but if afterwards he proves the case and obtains quiritary status, he thereupon begins to hold him in podesters. 67. Again, if a Roman citizen takes a Latin or a peregrine wife in a mistaken belief that she is a Roman citizen and begets a son, that son is not in his podesters, for he is not even a citizen, but either a Latin or a peregrine according to his mother's status, because, except if there be connubium between the father and the mother, a child does not take its father's status. But by a senatus consult the father is allowed to prove a case of mistake, and thereupon both the wife and the son attain to Roman citizenship, and thenceforth the son is subject to his father's podesters. The law is the same if by mistake he marries a wife who is in the class of deditici, except that the wife does not become a Roman citizen. 68. Again, if a Roman woman marries a peregrine in the mistaken belief that he is a Roman citizen, she is allowed to prove a case of mistake, and in this way both her son and her husband attain to Roman citizenship, and at the same time the son becomes subject to his father's podesters. The law is the same if under the Aelia censure she marries a peregrine in the belief that he is a Latin, for this contingency also is expressly provided for by the senatus consult. Up to a certain point the law is the same where she marries one who is in the class of deditici in the belief that he is a Roman citizen, or a Latin under the Aelia censure, except, of course, that the husband remains in his class of deditici, and consequently the son, though he becomes a Roman citizen, is not brought under his father's podesters. 69. Again, if under the Aelia censure a Latin woman marries a peregrine in the belief that he is a Latin, she can under the senatus consult, on birth of a son, prove a case of mistake, whereupon they all become Roman citizens and the son comes under his father's podesters. 70. The same has been laid down also for the case of a Latin marrying a peregrine woman under the Aelia censure in the belief that she is a Latin or a Roman citizen. Furthermore, if a Roman citizen, believing himself to be a Latin, for that reason marries a Latin woman, he is allowed, on birth of a son, to prove a case of mistake, as though his marriage had fallen under the Aelia censure. Also those who, being Roman citizens, but believing themselves to be peregrines, take peregrine wives, are allowed under the senatus consult, on birth of a son, to prove a case of mistake, with the result that the wife will become a Roman citizen, whilst the son not only attains to Roman citizenship but is also brought under his father's podesters. 72. All the above statements with regard to a son are to be taken to apply equally to a daughter. 73. So far as showing a case of mistake is concerned, the age of the son or daughter is immaterial, except where the proof is offered by one who thought he was contracting a marriage under the Elia censure. Such a person cannot prove a case if the son or daughter be less than 1 year old. I do not forget that a rescript of the late Emperor Hadrian is expressed as though, wherever it is a case of proving mistake, the son must be 1 year old. 74. Whether a peregrine who has married a Roman wife can show a case under the Senatus Consult has been disputed. 1. But where a peregrine had married a Roman wife and, after the birth of a son, had acquired Roman citizenship by some other means, on the question arising whether he could show a case, the Emperor Antoninus declared by rescript that he could do so just as well as if he had remained a peregrine, from which we infer that even a peregrine can show a case. 75. From what we have said it appears that whether a Roman citizen takes a peregrine wife or a peregrine a Roman wife, their child is a peregrine, but that if such a marriage has been contracted in mistake, its defect is cured under the Senatus Consult as explained above. But if there was no mistake, but they contracted the union with knowledge of their status, then in no case is the defect of such a marriage cured. 76. We are referring, of course, to persons between whom connubium does not exist. For otherwise, if a Roman citizen takes to wife a peregrine with whom he has connubium, a full civil marriage is contracted, as we have previously stated, and in that case their son is a Roman citizen and will be in his father's posters. 77. Also, if a Roman woman marries a peregrine with whom she has connubium, their child will be a peregrine and the lawful son of his father, just as if he had been begotten of a peregrine woman. But at the present day, in virtue of a Senatus Consult passed on the authority of the late Emperor Hadrian, the offspring of a Roman woman and a peregrine is the lawful son of his father even where connubium did not exist between the parents. 78. Our proposition, that the offspring of a Roman woman and a peregrine is, in the absence of connubium, a peregrine, is laid down by the Almanitia, which enacts that the child is to follow the status of the peregrine parent. In the reverse case, where a Roman citizen takes a peregrine wife with whom he has not connubium, the same lex provides that the offspring of their union shall be a peregrine. But it was in the case we are considering that the Almanitia was really necessary, for apart from it the child would properly have taken the other status, seeing that the child of persons between whom connubium does not exist takes his mother's status under the rule of the ius gentium. But the provision of the lex that the offspring of a Roman citizen and a peregrine wife is a peregrine seems superfluous, seeing that even apart from the lex the same result would follow from the rule of the ius gentium in any case. 79. This rule extends so far that the offspring of a Roman citizen and a Latin wife will be born a Latin, in spite of the fact that the Almanitia does not apply to those who at the present day are called Latins. For though not only foreign races, but also those called Latins, are covered by the term peregrine in that lex, the reference is to Latins of another kind, namely those who then possessed communities and states of their own and ranked as peregrines. 80. On the same principle, contrariwise, the offspring of a Latin husband and a Roman wife is born a Roman citizen, whether the marriage was contracted under the Elia censure or otherwise. The opinion has indeed been held by some that where the marriage is contracted under the Elia censure the child is born a Latin, because in this case connubium between the parties appears to be granted by that lex and the Unia, and the invariable effect of connubium is that the child takes the father's status, but that if the marriage is contracted otherwise the child follows the mother's status under the rule of the ius gentium, and is consequently a Roman citizen. But the law actually enforces as laid down by a Senatus Consult with the authority of the late Emperor Hadrian, namely, that in all cases the child of a Latin man and a Roman woman is born a Roman citizen. 81. Consistently, the same Senatus Consult, with the authority of the late Emperor Hadrian, has also declared that the child of a Latin man and a peregrine woman, and conversely the child of a peregrine man and a Latin woman, shall follow the mother's status. 82. From the same principles it also results that the child of a slave woman and a free man is born a slave by the rule of the ius gentium, while on the other hand the child of a free woman and a slave is born free. 83. But we must be careful to observe whether the rule of the ius gentium has not, in any particular case, been varied by some lex or by some equivalent of a lex. 84. Thus under the SC. Claudianum. It was possible for a Roman woman who cohabited with another person's slave with that person's consent, while remaining free herself in virtue of the agreement, to give birth to a slave, for the Senatus Consult ordains that what has been agreed between the woman and the slave's owner shall hold good. But subsequently the late Emperor Hadrian was moved. 1½ lines illegible in the Veronese Mus. By the hardship of the case and the legal anomaly to restore the rule of the ius gentium, so that the woman, where she remains free herself, gives birth to a free child. 85. Again, under a lex 2 it was possible for the children of a slave woman and a free man to be born free, for by this lex it is provided that, where a man has cohabited with another person's slave believing her to be free, their children, if male, shall be born free, but if female, shall belong to the mother's owner. But in this case also the late Emperor Vespasian was moved by the legal anomaly to restore the rule of the ius gentium, so that the children in every case, even if male, are the slaves of the mother's owner. 86. But that part of the same lex is unrepealed which enacts that the children of a free woman and a man known by her to be another person's slave are born slaves. Thus it is only among people among whom such a lex does not exist that the children follow the mother's status in accordance with the ius gentium and are consequently free. 87. It is abundantly clear that in those cases in which a child takes its mother's status and not its father's, the child is not in its father's potestas even if the father be a Roman citizen. This is why, as we explained above, in certain cases where, owing to some mistake, a civil marriage fails to be contracted, the Senate intervenes to cure the defect in the marriage and in most cases by so doing causes the son to be brought into his father's potestas. 88. But where a slave woman after having conceived by a Roman citizen is manumitted and becomes a Roman citizen and then gives birth, her child, though a Roman citizen like its father, is nevertheless not in the father's potestas, because it was not begotten in civil marriage and there is no Senatus Consult which enables such intercourse to be regularized. 89. The ruling that where a slave woman conceives by a Roman citizen and then after being manumitted gives birth the child is born free, rests on natural reason. For children conceived outside civil marriage take their status from the moment of their birth, thus if born of a free mother they are born free, and it is immaterial by whom she conceived them whilst she was a slave. On the other hand, those conceived in civil marriage take their status from the moment of their conception. 90. Hence if a Roman woman, being with child, is interdicted from fire and water, and having thus become a peregrine, gives birth, many draw a distinction, holding that if she conceived in civil marriage, her child is born a Roman citizen, but if in promiscuous intercourse, a peregrine. 91. Again, if a Roman woman, being with child, becomes a slave under the SC Claudianum because of her having had intercourse with another person's slave against the will and warning of his master, many draw a distinction, holding that if she conceived in civil marriage, her child is born a Roman citizen, but if in promiscuous intercourse the slave of the person whose slave its mother has become. 92. Again, if a peregrine woman conceives in promiscuous intercourse and then, having become a Roman citizen, gives birth, the child is a Roman citizen, but if she conceives by a peregrine in accordance with the laws and customs of peregrines, then, under a Senatus Consult passed on the authority of the late Emperor Hadrian, the child is a Roman citizen only if citizenship is conferred on the father as well. 93. If a peregrine petitions for Roman citizenship for himself and his children, the children will not come under his potestas unless the emperor subjects them to it. This he does only if, after examining the case, he judges it to be for the children's benefit. He examines with special care and particularity the case of children who are below puberty or are not before him. These rules are laid down by an edict of the late Emperor Hadrian. 94. Again, if Roman citizenship is conferred on a man along with his wife who is with child, although, as we have said above, the child is born a Roman citizen, it does not come under its father's potestas. This is laid down by a subscriptio of the late Emperor Hadrian. For this reason one who is aware that his wife is with child ought, when petitioning the emperor for citizenship for himself and his wife, to petition at the same time that he may have the expected child in his potestas. 95. Those who attain to Roman citizenship along with their children in virtue of Latin rite are in a different case, for their children do come under their potestas. 96. This right is one that has been granted by the Roman people, the Senate, or Caesar to various peregrine states. Two grades of it must be distinguished, for there is greater and lesser Latin rite. The greater right is where both those who are elected decurions and those who hold some high office or a magistracy obtain Roman citizenship. The lesser right is where only those who hold some magistracy or high office attain to Roman citizenship. This is laid down in a number of imperial epistles. 97. Not only are the children of our bodies in our potesters according as we have stated, but also those whom we adopt. 98. Adoption takes place in two ways, either by authority of the people or by the 2. No gap in the mus. But the name of some lex must have dropped out. Imperium of a magistrate, such as a praetor. 99. By authority of the people we adopt those who are sui juris. This kind of adoption is called aggregation because both the adopter is asked, that is interrogated, whether he wishes to have the person whom he is about to adopt as his lawful son, and he who is being adopted is asked whether he suffers this to take place, and the people are asked whether they sanction its taking place. By the imperium of a magistrate we adopt those who are in the potesters of their parents, whether they stand in the first degree of descent, as a son or daughter, or in a remoter degree, as a grandson or granddaughter, great-grandson or great-granddaughter. 100. The former kind of adoption, that by authority of the people, can be performed nowhere but at Rome, whereas the latter kind is regularly performed in the provinces before the provincial governors. 101. Further, females cannot be adopted by authority of the people, for this opinion has prevailed, but before a praetor or, in the provinces, before the proconsul or legate, females are regularly adopted. 102. Also, adoption by authority of the people of a person below puberty has at one time been forbidden and at another time been allowed. At the present day, under an epistle addressed by the excellent Emperor Antoninus to the pontiffs, it is allowed, if an adequate motive for it appears, subject to certain conditions. But before a praetor or, in a province, before the proconsul or legate, we can adopt a person of any age. 103. On the other hand, it is common to both kinds of adoption that those who are incapable of procreation, such as the naturally impotent, can adopt. 104. But women cannot adopt by any method, for they do not hold even the children of their bodies in their potesters. 105. Also, whether the adoption has been by authority of the people or before a praetor or a provincial governor, the adopter may give the person adopted in adoption to another. 106. Also common to both kinds of adoption is the dispute whether a younger can adopt an older person. 107. Peculiar to adoption by authority of the people is that, if a person having children in his potesters gives himself in aggregation, not only is he himself subjected to the aggregator's potesters, but his children also come under the same potesters, as grandchildren. 108. Let us proceed to consider persons who are in manu hand, marital power, which is another right peculiar to Roman citizens. 109. Now, while both males and females are found in potesters, only females can come under manus. 110. Of old, women passed into manus in three ways, by usus, confaritio, and coemptio. 111. A woman used to pass into manus by usus if she cohabited with her husband for a year without interruption, being as it were acquired by a rusicapion of 1 year and surpassing into her husband's family in ranking as a daughter. Hence it was provided by the 12 tables that any woman wishing not to come under her husband's manus in this way should stay away from him for 3 nights in each year and thus interrupt the usus of each year. But the whole of this institution has been in part abolished by statutes and in part obliterated by simple disuse. 112. Entry of a woman into manus by confaritio is effected by a kind of sacrifice offered to Jupiter Farius, in which a spelt cake is employed, whence the name confaritio. In the performance of this ceremony a number of acts and things are done, accompanied by special formal words, in the presence of 10 witnesses. This institution still exists at the present day. For the higher flamens, that is those of Jupiter, Mars, and Quirinus, and also the rex sacrorum, can only be chosen from those born of parents married by confaritio. Indeed, no person can hold the priesthood without being himself so married. 113. Entry of a woman into manus by coemptio takes the form of emancipation, that is a sort of imaginary sale, in the presence of not less than 5 witnesses, being Roman citizens above puberty, and of a scale holder, the woman is bought by him into whose manus she is passing. 114. It is, however, possible for a woman to make coemptio not only with her husband, but also with a stranger. In other words, coemptio may be performed for either matrimonial or fiduciary purposes. A woman who makes a co-MTO with her husband with the object of ranking as a daughter in his household is said to have made a co-MTO for matrimonial purposes, whilst one who makes, whether with her husband or a stranger, a co-MTO for some other object, such as that of evading a tutorship, is said to have done so for fiduciary purposes. 115. What happens is as follows: a woman wishing to get rid of her existing tutors and to get another makes a co-MTO with the auctoritas of her existing tutors. After that she is remancipated by her co-emptionator to the person of her own choice and, having been manumitted euindicta by him, comes to have as her tutor the man by whom she has been manumitted. This person is called a fiduciary tutor, as will appear below. 115a. Formerly two fiduciary co-MTO used to be performed for the purpose of making a will. This was at a time when women, with certain exceptions, had not the right to make a will unless they had made a co-MTO and had been remancipated and manumitted. But the Senate on the authority of the late Emperor Hadrian has dispensed from this requirement of a co-MTO. 115b. 3. But if a woman makes a fiduciary co-MTO with her 3. The reading of sections 115 or 115b is uncertain, and something is missing here.